And now, Joanna Steele from Bentley Stokes, she will speak about, piracy as a lawyer dilemma.
Thank you, Mauro. Maybe a little change of tempo after lots of very interesting talks about the current hot topic of armed guards within the context of piracy. My reflection starts back on World Maritime Day, and the Secretary General of the IMO, Mr. Mitropoulos, gave a message in relation to the scourge of piracy. And one particular point he made was this. More needs to be done, he said, including the capture, prosecution and punishment of all those involved in piracy, the tracing of ransom money and the confiscation of proceeds of crime derived from hijacked ships, if the ultimate goal of consigning piracy to the realms of history is to be achieved. What we've been talking about today are the concrete efforts across the global community to combat the scourge of piracy in a very practical way. We have talked about the move from BMP3 to BMP4. We've talked about the guidelines brought out by the IMO, and we have had considerable discussion about armed guards. What is very clear is that out in the Indian Ocean, the stakes out there at sea are now becoming considerably higher. Meantime, back on land, it's been a busy time for shipping lawyers. We find ourselves advising about the allocation of risks and responsibilities across all sorts of contracts. Our courts are beginning to get involved, cases are coming through. In the realm of charter party law, our courts confirmed in the case of the Saldanha last year that a time-chartered ship captured by pirates remains on hire unless you've got some useful terms in your charter party. So, of course, owners and charterers are now reallocating the risks with tailor-made clauses. The arrival of armed guards and the frequency of their use is also raising questions under charters, because we have people coming to ask us questions about the differing effects of, for instance, the BIMCO piracy clause versus something like the Con Wartime 2004 clause. In the marine insurance context, shipping lawyers are very busy too. We have just heard about the patchwork of insurance covers that are out there, the number of parties involved every time a ship puts to sea with cargo and crew on board. So naturally, we're advising on questions in relation to general average. We're looking in great detail at sue and labour clauses in all sorts of insurance policies. And it is in the marine insurance context that the question of the legitimacy of ransom payments has been raised. As Tracy said, we're not talking perhaps about the piracy that we all knew about 20, 30 years ago when I started out in this business. We're talking about kidnap at sea. This morning we heard about the case of Macefield AG and Amlin corporate members. And that was in the context of the definition of an actual total loss. But it was also in that case that the court was given the opportunity to talk about the legitimacy of ransom payments. And the Court of Appeal now tells us that the payment of ransom is a legitimate response to piracy. I'm going to read out to you what Lord Justice Ricks, however, had to say in this particular context. He said, "In these morally muddied waters, there is no universally recognized principle of morality, no clearly identified public policy, no substantially incontestable public interest, which could lead the courts, as matters stand at present, to state that the payment of ransom should be regarded as a matter which stands beyond the pale without any legitimate recognition." Now, Lord Justice Ricks is known for saying things in a very long-winded way, but I think what that statement reveals is, to my mind, the lawyer's dilemma. There are two key ethical principles of our professional lives. One, to uphold the rule of law. Two, to act in the best interests of each client. For shipping lawyers, we need to think very carefully about our navigation through these morally muddied waters. We find ourselves steering between the Scylla of the rule of law and the Charybdis of the best interests of our clients, working out responses to the criminality of piracy which keep our clients within the laws that may apply to them. And again, we've heard a great deal about this in the context of armed guards today. So, for instance, is it right to reduce questions about the employment of armed guards to matters of risk assessment and rules of engagement? Is it right to look at the mechanics of ransom payments in terms of compliance issues? Well, yes, in terms of serving our clients, it is. In terms of the rule of law, though, are we making it easier or more difficult to ensure that pirates are brought to justice and the proceeds of their crime are traced? And more broadly, is the mere fact that there are insurance-based solutions available and lawyers there to guide ship owners and insurers through the nightmare of piracy, is it contributing to a situation which will ultimately be unsustainable? We have a judge in the High Court who is rather more blunt in his use of the English language than Lord Justice Ricks. And Mr. Justice Steele was given the opportunity in the High Court, before Lord Justice Ricks, to talk about the current situation of Somalia. And he described it this way. He said, "It's clear that Somali pirates take vessels in order to ransom them and invariably negotiate with the ship owner or other interested party for the release of the vessel, cargo and crew, in exchange for a payment which represents an economic proportion of the value of the property at stake." On that view, piracy in the Gulf of Aden and Indian Ocean can be looked at in terms of a market, an economic transaction, plain and simple. Communication between pirates and ship owners and their advisors is straightforward, bargains can be struck and procedures can be put in place. I ask myself, are we monetizing matters in a way which really is in the best interests of our clients? Will there come a time when the market can no longer support the sums involved? Even now, setting aside any questions about whether the market will always be able to price the risk, the reality is that this market is not open to all participants. Differing reasons, but maybe it will be because the value of the property involved is not high enough, or that there are no insurances in place, or that the pirates have captured people and not property. The spiralling expectations of the market make these situations particularly difficult. So, within the last year or so, as the costs of the response to piracy have spiraled, we have seen the development of an arms race out there at sea. The change in attitude to armed guards between the publication of BMP3 and BMP4 suggests that many more merchant vessels will now be engaging with the pirates. Their armed guards may be doing things in self-defense which raise the stakes for everyone. The shipping lawyer's dilemma will be ever more acute. No doubt we can and will act in the best interests of our clients in looking for ingenious solutions to problems and answers to questions about contracts, insurance, general average and the like. But if that means that we continue to ensure a flow of ransom money and a reward for piracy, can we in truth continue to uphold the rule of law as the risks at sea increase and those transactions become more deadly?